The pen was still in my hand when my brother's wife started texting people from the hallway. I could hear the little chime of her phone through the half-open door of the notary's office, one after another, and I knew exactly what those messages said without reading a single one. I should back up. My mother was diagnosed with early-onset vascular dementia in the spring, 2 years before she died. She was 67. The neurologist at St. Michael's used the word accelerated, which is a careful clinical way of saying that the window for recognizable moments would close faster than any of us were ready for. I drove home from that appointment alone because my brother Garrett had texted that he couldn't make it, something about a site inspection in Mississauga that couldn't be moved. His wife Renata sent a flower arrangement to my mother's apartment the following week, with a card that said, "Thinking of you always," which I thought was a generous thing to send to a woman who was increasingly uncertain what day it was. I work as a licensed paralegal in Toronto, primarily in estate and family law. I have spent a significant portion of my professional life helping people navigate documents they don't fully understand, under circumstances they didn't choose. I know what coercion looks like in paperwork. I know what urgency manufactured for legal purposes sounds like. I know the difference between a real deadline and a deadline that exists to prevent someone from thinking clearly. I mention this not to position myself as someone who had all the answers, but because understanding what was happening to me didn't make it easier to live through. My mother lived in a 2-bedroom condo in Etobicoke that she'd owned outright since my father died in 2011. She had a small portfolio of GICs at TD, a modest RRSP, and the condo itself. Nothing extraordinary. The kind of estate that takes 3 months to administer and causes no one any particular difficulty, unless someone decides to make it difficult. For the 18 months between her diagnosis and her death, I was the one who managed her care. I coordinated with her geriatric care team at Sunnybrook. I hired and vetted 2 PSWs who came on alternating days. I attended every specialist appointment, updated her medication list after every change, liaised with her building superintendent when the bathroom grab bars needed reinforcing. I learned more about vascular dementia than I ever wanted to know, including the specific ways it distorts time and trust and the face of the person you thought you knew. Garrett visited on long weekends and at Christmas. Renata came with him roughly half the time. Their visits had a particular quality I came to recognize. A kind of performative warmth directed slightly past my mother towards some imagined audience, the way people behave when they want the record to show they were present. Garrett would sit beside her on the couch and talk about his renovation projects in a loud, clear voice, as though volume could substitute for connection. Renata would reorganize the kitchen while they talked, which was something my mother had specifically asked her not to do, because the disorientation of finding things in unexpected places was genuinely distressing for her. I mentioned this once. Renata said she was just trying to help. Neither of them offered to pay for any part of the care. I want to be careful here because the money was not, in the end, what mattered most. What mattered was that my mother knew who I was for longer than the doctors had predicted. And I was there for most of those moments. And I will carry that for the rest of my life in a way that no estate proceeding can touch. But the money is part of the story because it's how I understood what Garrett and Renata actually believed about what I was owed. The conversation started at the reception after my mother's funeral. We held it at a hall in Etobicoke, about 40 people, mostly her friends from her book club and her old colleagues from the insurance company where she'd worked for 22 years. Garrett waited until most of them had left. He found me near the coat check with a drink in my hand and what I imagine was a face that had been doing the work of a composed face for approximately 6 hours longer than faces should have to. He had a folder. I have since learned that the folder is a recurring feature of this kind of conversation. It signals preparation. It signals that this is not an impulsive moment, but a planned one, which somehow makes it worse. Inside were printouts, an appraisal for the condo that placed its value significantly below current market, a summary document he described as an accounting of shared family expenses, and a one-page letter on what appeared to be legal stationery outlining what he called the equitable restructuring of our mother's estate. He explained, with the patient tone of someone delivering news they'd rehearsed, that the condo would need significant remediation before sale. He had a contractor friend who'd assessed it, and that after accounting for shared costs he and Renata had absorbed over the years, the most sensible outcome was for me to accept a reduced share of the liquid assets and waive my interest in the condo entirely, which he would list and sell through a contact of his, someone who could move it quietly without agent fees. He said this while our mother had been dead for approximately 5 hours. I asked him what shared costs he was referring to. He mentioned the Christmas visits. He mentioned a weekend trip he and Renata had taken her onto Niagara-on-the-Lake 2 summers before her diagnosis. He mentioned, and this is the part that required the most effort to hear without expression, a contribution he said they'd made to a home repair fund she'd apparently mentioned to him. A repair fund I had no record of and that appeared nowhere in her banking documents, which I had been managing for over a year. I said I'd need to review everything carefully. He said he understood, but that the estate lawyer, his estate lawyer, a man named Aldrich, who I had not previously heard of, had a filing window approaching and that delay would complicate things for everyone. I drove home. I poured a glass of water. I sat at my kitchen table with the folder, and I went through every page. The condo appraisal was not from a licensed appraiser. The stationery that Aldrich's letter was printed on listed an address that corresponded, when I searched it, to a shared office suite downtown, the kind where you pay monthly for a mailing address and a boardroom by the hour. The home repair contribution Garrett had mentioned did not appear in 18 months of my mother's bank statements, which I had organized into a binder by quarter, because that is the kind of person my profession has made me. I called my colleague Daphne the next morning. Daphne does estate litigation. We've referred clients to each other for years. She reviewed the documents over lunch at a place near our office on Adelaide and identified the appraisal as non-compliant with CU SPAP standards before she finished her soup. She flagged 2 additional issues with Aldrich's letter. The filing window he'd cited didn't correspond to any actual Ontario probate timeline she recognized, and the language of the equitable restructuring appeared designed to look like legalese without actually containing any enforceable terms. The urgency, she said, was theater. That evening, I went to an electronic shop on Bloor Street and bought a small digital voice recorder, the kind that fits flat in a jacket pocket. I've used them before in my work, for client consultations, always with disclosure. This time I did not intend to disclose it. In Ontario, it is legal to record a conversation you are a party to without informing the other participants. I had known this for years. I had never before had personal reason to use it. I texted Garrett that I wanted to meet and talk through the estate documents before making any decisions. He responded within 4 minutes. People who believe the outcome is already settled tend to be very available. We met at a restaurant in Bloor West Village. His suggestion? Somewhere Renata liked, though she wasn't there. He arrived with the folder again, or a version of it, updated with what he described as additional documentation. He ordered a glass of Shiraz. I ordered sparkling water. I had the recorder running before I sat down. I asked him in the most neutral register I could produce, what would happen if I chose to retain my full share of the estate and have the condo independently appraised through the estate's own process? His response was not measured. He said that Renata had been patient, but that patience had limits. He said that if I complicated what he called a straightforward family resolution, he would be forced to file a dependent support claim on behalf of my mother's estate, a claim alleging that I had been compensated through use of the condo and other informal arrangements for my caregiving, and that this compensation should be treated as an advance on my inheritance. He said this with the calm of a man who had rehearsed it with someone who was either Renata or Aldrich. He named a figure. He said the number twice. I had never lived in my mother's condo. I had a lease on an apartment in the Junction that I'd had for 4 years. The suggestion that I had received any informal compensation was, I am choosing this word precisely, fabricated. He said one other thing before the food arrived about what happens to professional reputations in small legal communities when family disputes become public filings. He said it in the careful language of someone describing a natural consequence rather than a threat. I noted that he'd said it. The recorder noted also. 2 days later, I sat in the office of the estate's actual lawyer, my mother's lawyer, a woman named Miss Olwellette, who had drafted the original will and whom Garrett had apparently been trying to sideline in favor of his associate, Aldrich. Keir was there with Renata at this time. Renata had dressed as though attending something formal. The waiver document was on the table. It was 3 pages. There was a pen. Garrett explained for Ms. Ollette's benefit and for the record that I had agreed to the terms following a family discussion. He said this clearly and with confidence. Renata nodded. I let him finish. Then I picked up the pen and signed each page. The satisfaction on their faces had a specific quality. It was the satisfaction of people who had constructed an outcome and were watching it arrive on schedule. In the hallway outside Ms. Owillette's office, I had perhaps 6 minutes. I used them to send the audio file from the restaurant to Ms. Riolette. Owillette's secure email portal, with a subject line that read, "Recording courting, relevant to estate proceedings. Please review before processing signed waiver." I sent a copy to the Law Society of Ontario's intake line with a note about Aldrich's letter and the fabricated address. Then I walked back into the building lobby and waited. Garrett and Renata emerged about 4 minutes later. Renata was already on her phone, typing with both thumbs. Then Garrett's phone rang. He answered it. I watched his face from 20 feet away. What I need to explain about my mother's will is that she had not been careless with it. She had updated it 14 months before her death, during a period when her cognition was still intact, and she had been, I later learned, concerned enough about family dynamics to ask Miss Ollett about protective provisions. Miss Ollett had included a clause, standard in her drafting practice for exactly this kind of situation, providing that any beneficiary found to have made fraudulent representations or applied undue pressure against another beneficiary in connection with estate matters would forfeit their entitlement entirely. It was a clause my mother had specifically requested after a conversation she'd apparently had with Ms. Olette about what she'd observed in other families. She had been watching. She had been thinking ahead. Even then, Aldrich's phone call to Garrett lasted approximately 7 minutes. I didn't hear the content. I didn't need to. I watched Renata stop typing. I watched Garrett's posture change. I walked out through the lobby doors into the cold November air on St. Clair Avenue, and I drove home. The surrogate court's ruling came down 9 weeks later. The waiver was set aside on the grounds of duress and fraudulent misrepresentation. Garrett's claim to the estate was forfeited under the will's own terms. Miss Owlett filed a referral to the Law Society regarding Aldrich's conduct in the matter. I was told the shared office suite he had listed as his address was connected to 2 other ongoing complaints. I didn't feel victorious. I want to say this carefully because I know what the story sounds like from the outside. I felt tired in a way that I'm not sure has a name. The specific exhaustion of having had to be strategic about people who were supposed to love you. My mother died, and then I spent 3 months building a legal case against my brother, and both of those things are true at the same time, and the second one doesn't cancel the first. I used a portion of the estate proceeds to pay off what remained of my mother's outstanding care invoices. There were a few from the final weeks that had come in after the estate was opened. I put the rest into a TFSA. I took a week off work. I went to a grief counselor at a clinic in my neighborhood who told me that it is possible to love someone and simultaneously grieve the version of them you thought you had, and that both losses are real, and that I didn't have to choose which one to mourn first. I haven't spoken to Garrett since the ruling. I don't know if that's permanent. I know that it's necessary for now, and that necessary and permanent are different categories of decision, and I'm not ready to sort that out yet. What stays with me, what I find myself returning to when I'm at my desk reviewing someone else's estate documents, is how close I came to simply letting it go. Not because I believed him. I didn't believe him. Not for a moment. Not after I saw that folder. But there's a particular kind of exhaustion that follows 18 months of caregiving, and it makes the idea of one more fight feel like a weight you genuinely cannot lift. I almost decided that the condo wasn't worth it. I almost decided that peace, even manufactured peace, was better than another year of documents and phone calls, and knowing that my brother was watching the clock on my grief. I bought the recorder on a Tuesday. By Thursday, I had what I needed. The distance between those 2 days and the version of my life where I just signed and let them have it is smaller than I'd like to admit. I think about the people who don't buy the recorder, who are tired in the same way and make a different calculation, who sign the papers and spend years afterwards wondering whether the thing they let go of was the estate or something else, something less recoverable than a condo in Etobicoke. I'm a paralegal. I understand documents. I understood what was being done to me while it was being done to me, and it was still almost enough. That's the part I keep coming back to. Not the victory, the almost. If the people closest to you were the ones building the trap, how long would it take you to see it clearly enough to act? And what would you need to believe about yourself before you decide that acting was worth it?